Good morning, everyone. I'm just gonna wait for you guys to tune in. I am late today. I had a meeting running late, so I'm late today. So I don't have much time because I was in a meeting. But how's everyone doing? I'll try and just answer as many questions as I can. I know there were questions yesterday that I couldn't get to, even though I don't remember most of them, but I will try and address. Good morning, RTM, Shanette Solomon. Good morning. Good morning, everyone on Instagram and YouTube. If this is your first time tuning in, welcome. Nash on YouTube. Good morning. Let me pin this. Let me pin my phone number. Okay, good morning, everyone. If this is your first time tuning in, my name is Aisha Chidole. I'm an immigration attorney in Atlanta, Georgia. I represent clients all over the United States with their immigration matters. We handle humanitarian-based cases like VAWA cases, T cases, which is trafficking visas, U cases, which is for victims of a serious crime. We also handle family-based immigration, so marriage-based cases, fiance cases, parents, children, siblings, removal of conditions, and then we also handle removal proceedings. I'm sure some of you have met with Attorney Stacy, who leads our removal department here, and some, bond and detention. Okay, someone is saying that they have a question, so go ahead and ask your question. While you are typing that, my phone number here is 678-325-1037 or 678-233-2170. You can also send a WhatsApp on 404-333-8751. The numbers are saved, on here. And it's also in my profile. You can also just book a consultation yourself by going on our website or type in chidowaylaw.com/booking to book a consultation yourself. So let's get right into it. Someone is asking, are there any updates on the Supreme Court's ruling on child birthright? So we are expecting that on Thursday, guys. Let's keep our fingers crossed. Different people have asked me, what do I think would be the outcome? Honestly, I truly don't know. The biggest, basically what it is that they're arguing is what really under the jurisdiction of the United States means, essentially, and whether it's people who are on the soil of the United States or whether it's people who are here in some permanent capacity. In the last week, obviously, the Supreme Court has made decisions that have been hurtful and some that have been helpful. So truly, I really don't know. In the past, you could say certain things with confidence, but honestly, because there are certain decisions where I'm still harping on the Supreme Court's decision on TPS and just terminating it just like that, to me is so harmful for so many people because of, not only the country conditions, but again, because these people are not illegal migrants. These are people that were authorized to be here, which means that they have dedicated or sold off everything they have to make this home. And so to just say we're going to just snap that, go figure out how you're going to find a place to live, food to eat, money to pay your bills, a job or whatever it is, it to me is really cruel. So that was really, really shocking, but then they've also, said basically, they've also made the ruling, that with voters, mail-in voting, they would accept the votes as long as it's mailed before election day. So it's a toss-up, so I really don't know what's going to happen with the birthright, but, let's keep our fingers crossed and see, what happens on Thursday. Someone says, if you were placed in removal proceedings, but you already have your marriage-based green card application, what is the timeline? Well, this question is very vague to me. I don't know if you're asking if you have your case. Do you mean is your marriage-based case pending with like your 485, is it pending with the court? That's EOIR, like with the judge, or did you file that with USCIS? So it depends, the answer depends on your question, because, if it's with USCIS, there's, the normal USCIS timeline for them to interview you. But one of two things can happen, depending on when you got your, your NTA, which is your notice to appear in front of an immigration judge. Some officers, if you're eligible, will approve you for a green card and then you have to go to court and then terminate it. Some will administratively close your removal, your I-485, that's with USCIS, and tell you to go terminate that with the courts, and then come back. In our case, the scenario that we had, that we got terminated recently, and I talked about it and showed you guys as well, because I'm not someone that likes to just talk and you can verify it. I like to show the proof, the social proof, because I don't have time to, lie or give BS. Like, I want people to know the different scenarios or the different options they had. With our client, as I had mentioned, I think I talked about this in April, because it happened in April. They filed, their 485 was denied. They filed themselves. The 485 was denied for something really silly. And then they came to us, we filed again. And after we filed, a month later, they got a notice to appear in front of an immigration judge. So they were in removal. And I remember we went to actually, I tried to cancel the interview at first. And I said, and that was also around the period where like a lot of detention was happening. Client was concerned about detention at USCI. So I said, well, why are you guys interviewing them if you don't have jurisdiction? And USCI said, well, we're not going to cancel the interview. Since we scheduled it, just go ahead and come. Then, something happened with the weather, and so they canceled the interview. And then they rescheduled them for another interview. And so we went to the interview, and, we had already talked about if they were going to detain, the process of getting them out of detention, knowing that they would still be able to take advantage of the fact that they're married to a U.S. citizen and continue their case in court. We went, and the officer really wanted to understand what happened the first time, why the case was denied. We explained everything to her, and she was like, so what would she was saying to me, what would I want? I said, well, I want you to approve my client, but if you can't approve them, just administratively close the case so that we can go to the court and say, terminate it so we can finish, and approve the I-130. But she did one better. She approved the green card. So as soon as they mailed the green card, the client got approved like within 24 hours. They mailed us the green card, and we immediately filed a motion to terminate in front of the judge. We just bypassed, opposing counsel. There was no point of getting a joint motion. We just bypassed it, and the judge approved it and said, we've presented enough evidence that the person should be here because they obviously got approved for a green card. So to answer your question in a short version, it will depend on when you submitted your 485. And did you get your NTA before your 485, or did you get the NTA and then you submitted the 485? Okay. My I-130 is approved, but my 485 went on to be reviewed. What does it mean? It means that they're reviewing it. So an I-130 typically is basically telling them that whatever relationship that you're applying under for the I-130, that is a genuine or good faith relationship. The 485 is your own personal application to determine your own admissibility into the United States. Right now, there's a lot of extra vetting that's being done, like for green card holders or to approve people for citizenship. It is possible that is what they're going through with yours. If after 90 days, they haven't adjudicated that, but you have the I-130 approval, I would say that you should reach out to them, because if there's something that they need to make a decision, then they should send it to you, so you can give them whatever they need so they can make a decision. Okay. Okay, this person says, I'm from Nigeria. I filed a concurrent VAL application, but I haven't received a prima facie determination letter, work authorization for the last 13 months. What should be the solution? You need to do an inquiry. This is for you, Steve. I have a feeling that you haven't met the requirements for the prima facie determination, or if you have and they mailed the prima facie, they mailed it to the wrong place. So one of the things that you can do is to do an inquiry to find out what is it that they're missing? What is it that they need to give you a prima facie determination letter? So they should either issue that in form of an RFE, and if there's nothing that they need, they should give you the prima facie determination letter. So that's what I would suggest. And then Girl JJ says, my best attorney, please, I filed for VAWA since 2022. I have one prima facie, one work permit for 2 years. It's expired, and I filed for renewal. But since last year, I received a receipt notice in December. Nothing yet received yet. Okay, so you're basically saying that you filed for a renewal of your work permit in December 2025. I think yesterday I had mentioned to you guys I was going to pull up the most recent work permits and travel permits just to kind of give you a trend. All the work permits and travel permits that I pulled up about 12 just because I wanted to just kind of see a trend. What I saw was that the travel permits were all approved between 11 to 14 months from application, which is now really a long time. And I'll get into a strategy for that in a second. And that the work permits were all approved between 10 to 12 months, which is also really a long time in my opinion, but it just seems that that's the direction the USCIS is going. And as that's what they've also published on there, that it's taken 10 months, which is why a lot of people who apply for, like, say, a marriage-based case will end up having their interviews even before they get their work permits, because those interviews are moving very quickly, like 6 months, 7 months, 8 months, so depending on, the situation, that might be what will happen. Now, are there people that are going to get work permits and travel permits earlier? Yeah, it depends. There's no rhyme or method to it, but sometimes some people just luck out and theirs comes out earlier. If you are waiting on a travel permit and you really need to travel, one of the things that I would recommend is just trying to do an expedite. You can only do an expedite 45 days before the trip, and it has to be either an urgent humanitarian need or emergency, or serious loss of financial stuff, or anything related to we had a client basically who her sister was getting married and she was a maid of honor. So we provided that and they were approved for the emergency one. So expedite is different from emergency travel permits. Expedite means that you're submitting in 45 days before and asking them to send it. And emergency is where you schedule an info pass and actually bring your I-131 form to the office and you present whatever the emergency is, or someone passed away, here's a death certificate, I need to go, or whatever it is. So if you don't need to travel in the immediacy, doesn't really matter when your advance parole gets whatever. But if you have something that falls under that, you can try to expedite it or try to request an info pass to do it. Okay. All right, let's see what other questions we got here. I don't have a lot of time today though. Okay, someone says Yolanda says, I had an interview in February. I waited for 120 days. Yes, so right now you should do an inquiry to USCIS to check on the status of that. Okay. Can Nigerians now file for citizenship? Nigerians were never not allowed to file for citizenship. Of course, you can file for citizenship if you are in the United States. The ban is for certain cases outside of the United States. There was a pause on approving cases in the US, but the pause has been lifted and we are actually seeing people get approved. Yesterday, we got 2 family members, I think it might be 3, who had, and we're going to post this on Friday, when we do our weekly updates of countries and different approvals, where they got their own travel permit from Nigeria as well. So they are making decisions, but again, let me repeat and be clear. You were never not allowed to file for citizenship. They just would not approve them once you got to the interview stage based on the pause. The pause has been lifted. So again, you guys know litigation takes time, right? Because this thing happened in January, and then what happened, this lifted in June, right? So that's 6 months or five and a half-ish months. So before the next set of hearing or the court can hear whatever, is going to take several months. So if you are eligible for citizenship, especially citizenship that takes a shorter time, you better put in your application and get your stuff together. This is assuming that the appeal doesn't agree with the lower courts. So put that in, even though this is the one area that I feel confident that the next court will agree with the lower court, because This is meant to be a temporary pause, and this was meant to be a temporary pause for 90 days. But after 90 days, they didn't do what they said they were going to do, nor did they give any instructions of what they were going to do. So it's kind of like arbitrary and capricious. Like, what are you doing? So this is one where I feel confident that, but again, I don't know, but I feel more confident that the appeal will basically agree with the same thing. Okay. Can you apply for naturalization while your I-751 is still in process? The answer is going to depend on how long you have had your green card. So technically, yes, you can, but you want to make sure that you're applying based on the correct timeline, which is if you are in a marital union and you're in a joint marriage, then you can apply 3 years from the date you got your green card and fully expect to attend that interview with your spouse and fully expect to bring that good faith evidence of marriage. If you're doing it based on a request for a waiver on divorce or death, then you're looking at 5 years from the green card date. If you're doing it based on an I-751 waiver of extreme cruelty abuse, then you can do it 3 years from the date on your original 2-year green card. Okay. I have a friend, says, good morning. Thank you for your educational live sessions. I have a friend from Haiti who filed for VAWA in September of 2025 and didn't receive a receipt notice until about 6 months later. Is it typical to still be waiting for both a prima facie and a work permit at this stage? Work permit, for sure, it is still typical. I just talked about that 5 minutes ago, but I guess maybe you just logged in. Work permits are taking about 10 years. 6 months is normal for a prima facie. If after maybe 8 or 9 months she hasn't heard anything, I would say that she should definitely try and do an inquiry to see if there's something else that they need to make that determination, for her, for it. But okay, guys. Okay, I have a few minutes that I can stay on. Let me just make sure. I'm checking my calendar real quick. So I got a few minutes so I can answer some more questions. So someone says, I was thinking my VAWA case is 4 years now, and I filed in 2022 to 2026. Is it because I'm from Nigeria? I've not worked for 14 months now, and I have 13 years old me. I'm just worried. So I don't know if the question is about your work permit or about your VAWA. So your VAWA is not because you're Nigerian. All VAWA cases right now are facing a very long delay. They're facing a very long delay. They're facing a lot of scrutiny. You better make sure that when you're submitting your VAWA application, you're very thorough, you're very detailed, not just like random summaries or sound bites. You need to make sure your declaration really tells the story of you and your spouse, good faith marriage, shared residence, the abuse you experienced, not just saying, oh, my spouse is abusive. Oh, my spouse says bad words to me. You need to get into it. Get into the examples of what is happening. You need to be able to tell that. USCIS is looking to see consistency and tell their story to show a totality of pattern of behavior, especially because, I'm sure many of you have heard in recent news, there have been some allegations of fraudulent claims and all of those things. So you want to really make sure that you are setting your best foot forward in your application. So because of that, a lot of these cases are being interviewed. And when you have humanitarian-based cases that are extensive packets being interviewed, those automatically are going to delay these cases. Think about asylum, for example. In an asylum application that's filed with USCIS, most of those cases take 7 years, 6 years. That is because they go through interviews. So now with VAWA cases being scheduled for interviews, it is causing that delay for so many. I think that's part of one of the things that's causing it. As far as your work permit, you said it's been 14 months. If you filed for the proper work permit, which is under CO9, and you had a 485 pending, I would say you should reach out to USCIS. I would say you should talk about, the fact that, you're dealing with a financial crisis, essentially. You don't want to be a burden to society, even though as a VAWA applicant, you might have a prima facie determination letter that might allow you certain state benefits. You want to be able to work. You want to be able to pay taxes. You want to be able to have a bill. If you're facing eviction, if you're moving from house to house looking for a place to stay, for your child to stay, you have nothing to lose, right? Other than reaching out or seeking an attorney's counsel to see if that is enough for you to submit a request for an expedite on your work permit. Now, they may not approve it, but like I always say to my kids, closed mouths don't get fed. So you won't know unless you try. You know what I mean? Okay, after sending what they need on the, I think you're trying to say RFE, how long does it take to hear from them, please? The answer is going to depend. It's really going to depend on what kind of case you have, what stage your case is in. So it's really hard for me to say because I don't know where you are in your process. I don't know what kind of case you have. So I can't really say for certain. I don't know if this is a marriage-based case or another kind of case. If your partner doesn't want to sign your document for your green card extension, what do you do? So let me simplify that. I think what you're trying to say is that your partner doesn't want to file an I-751 jointly with you. If your partner doesn't want to file an I-751 with you, it is very critical that you speak with an attorney. Speak with an attorney to find out if you're eligible for any other grounds of the waiver. Why? Because this is very critical, because if you do not submit that on time, USCIS will send you a letter terminating your green card. In fact, we had a client who we represented and closed their case, but because our address is on the client's record, we got a letter on their behalf. I don't know where the client is. This is a former client, meaning like we're done with their case. We got them their green card, but they and their spouse never filed the 751, and we got a letter basically yesterday saying, they've terminated his green card because he didn't file. And if they terminate your green card, they're sending you to deportation court. So if your spouse is not willing to file with you, you need to be screened to find out if divorce is a better option for you. If your marriage is not working out, the key thing is that you have a genuine marriage, because what they're going to want to see is good faith marriage. The other thing is, if that is not an option or is not viable for you, then, which to me, if that's not viable for you when you have a spouse that's willing to destroy your future here in America, I'm not really sure what you're trying to say, because your spouse has already tried to destroy you by getting you deported, which means they're not trying to save the marriage. If that is not an option for you, then you want to look at extreme hardship. Extreme hardship, the hardship cannot be something that happened in the past or what happened like back in your country or whatever it is. The hardship has to have begun at the time you became a green card holder. Extreme hardship is one of the most difficult waivers to get, but if you have true hardship that you can document, that is also another option. And then, of course, the third option is going to be if your spouse is extremely cruel and abusive to you, you can also do that. When you are filing a 751 with extreme hardship, extreme cruelty and abuse, USCIS is expecting much more evidence of that than, say, if you're filing a valid petition. Because at this point, you've got a green card, you have a social security number. You shouldn't be afraid to call the cops. You shouldn't be afraid to talk about it in the hospital. You shouldn't be afraid to reach a therapist. You shouldn't be afraid to have evidence of things together or whatever it is. So they're a bit harsher with that. So, but those would be waiver grounds that you'd be eligible for, if you qualify. Okay. All right, let me answer some other questions on Instagram. YouTube is busy today. Okay, someone from the Caribbean, welcome. How much months worth of bank statements is needed to remove conditions on the green card? There is no set amount, but when you are thinking about submitting bank statements for like your I-751 based on conditions on your green card, you want to count back, the most recent bank statements and count it back. Basically, if your green card expires, let's say, what month are we in? Let's say it expires August of 2026. The evidence that I would want to submit would be July's bank statement, June's bank statement, assuming you've submitted in August, June's bank statement, May, April. Try to go back at least 6 months or at the very at the very minimum 3 months. I make this assessments and decisions based on what is happening in the bank account and transactions happening. If there are lower transactions within a certain month, I want to go back to when there are more transactions going on, in that bank account, just to show some sort of consistency, or maybe to give some context to why nothing is happening, during those months. And, some people might ask, what do you mean by that? Like, for instance, like sometimes, a client might submit a bank statement to me where like, it's on a zero balance and maybe like only $11 it's in there. Like the first thing I'm asking right away is, why is there only $11 in this bank account? This whole month, where did you not, did you work? Did your spouse work? Was there no money? Like, explain that, because otherwise it just looks like a placeholder, so you want to be very, and that's, well, I guess that's where lawyers come in. For us, we have to use an analytical and strategic eye when we're looking at evidence that's being submitted, and automatically start thinking about all the objections and all the questions that an officer would have. If I have a question and the answer is not addressed within the caption, I'm very big on captions, So if you're my client, you probably see all those red lines and red captions on every evidence that we send that requires context, because that's just how I work. Because I believe in making it easy to present my evidence. If I submit something and I have a question, it means the officers are going to have a question. So we're putting a box in there and explaining what this evidence is. So aside from your table of contents, we want that box to explain what the evidence it is that we're submitting, or why this evidence is this way, So there's no count per se of how many you should submit. It's really more about, the quality of the evidence. And this goes to any kind of evidence you submit. It's quality over quantity. Someone says, do you think the Supreme Court will align with that of the federal court, and will its verdict be immediate? I'm not sure what this question is. For which case? Which case are you referring to? This is from Mr. Sai. As a green card holder via VAWA, I always get pulled over for secondary inspection when I travel abroad. With this recent issues, I have taken a pause on international travel, but what are your thoughts? What do you mean, what are my thoughts? You always get secondary. If you are someone that gets secondary inspection, you always get secondary inspection. Secondary inspection is fine as long as you're able to answer the questions. You get, and then, they let you in. So as long as you're able to answer the questions, secondary inspection is fine. Secondary inspection was happening before this administration for many case types. Now, if you are a green card holder that has a pending criminal case, or a case that might result in a crime of moral turpitude, you definitely do not want to be making any international trips right now, because as you guys have seen, that the courts are basically saying that CBP has the option to refuse entry as a green card holder based on that, and parole you in as an arriving alien. What does that mean? When they say refuse entry and parole you as an arriving alien, what it means is they will let you in, but possibly place you in detention so that you can go to court and decide whether this whatever the case that you're being suspected of or you're being tried for, is that something that would get your green card terminated or not. So yeah. Okay, so someone says the pause that has just been taken off. Oh, okay. So Mr. is saying that do you think that the Supreme Court, well, we're not yet at the Supreme Court level, so we're still at the appeals level. So let's see what happens with the appeal. And depending on what happens with the appeal, then I'll be able to tell you what I think might happen. RTD says they don't even ask questions. They just take my passport, look within their system, and send me away. Yeah, so that's fine. Like secondary inspection happens. This is not unique to this administration. Some clients get secondary inspection. So the quickest way to get rid of secondary inspection is as soon as you're eligible to become a U.S. citizen, become a U.S. citizen, file for your citizenship, so you can keep it moving. Okay. Okay. Are you seeing denials for overstays? It appears that folks are getting their I-485s denied solely due to overstay. That whole officer discretion saga, can you talk more about this? Personally, no, we haven't seen those in our cases, but also since the announcement, we have prepared all our clients for them. Our applications are prepared to discuss that. That's what I'm talking about is positive equities and negative equities. All our cases are prepared to discuss that. When we prepare clients for their interviews, we are also prepared to discuss that. So we haven't seen that in our firm, knock on wood. Shamika Hamilton says, thank you for all you do, Aisha. Oh, thank you so much. Okay, let me answer this other question. There's a question I wanted to answer here. USCIS received my VAWA package since June 2nd. So far, nothing regarding the receipt notice. I'm from Congo, Kinshasa, and applied for VAWA. USCIS received the package. Well, first of all, shout out to Congo and your soccer team. I mean, you guys are doing it. I'm loving that. And secondly, you just submitted your file like literally 4 weeks ago. That's normal. You're in a very, very normal period. It takes about 6 weeks, 7 weeks to get your receipt notice. So you're still in a very normal timeline. So don't worry for anything. You don't need to worry. You're still in a normal timeline. As long as you tracked your delivery to make sure that it was delivered to the correct address, your receipt should be forthcoming. Okay? Okay, so let's see. Well, I haven't yet seen anything. Maybe they've ruled on birthright citizenship. I don't know. But, it seems that some people, you guys should tell me because I'm on live. So I'm not in news. Like I'm typing right now and it seems that they are waiting. They're waiting for a decision. So the decision is going to come today. The decision is going to come today. It's live, but Supreme Court has rejected President Trump's executive order, which aims to end birthright citizenship. That is amazing. I am getting this live with you guys. Wow. In a 6-3 decision, the Supreme Court struck down the executive order which limited birthright citizenship for children whose parents are not U.S. citizens or permanent legal residents. Yes, this is amazing news. Wow. I'm literally hearing it live with you guys for the first time because I'm on live. So that is amazing, and what we thought was going to happen. So, carry on, guys. What a great day, to uphold the Constitution. It gives some hope that, even though the Supreme Court is packed, towards a certain persuasion that, they are still holding and upholding the law when it's very clear what the Constitution says. Somebody cannot just go and arbitrarily change the Constitution. So thank you, Jesus. For those of you who don't believe in Jesus, thank you, God. Thank you, universe. Thank you, whoever. But that is amazing news. Amazing news. See, I'm here on live and I'm missing all the news because I'm talking to y'all. So thank you guys for informing me. Amazing. Okay. All right. So let's see what's up. I mean, just for nothing. And that's why I said that I felt confident about the pauses, because again, they're capricious and arbitrary, right? They don't serve any purpose, because if you are saying that you're pausing something, but for only specific groups of people, without proof of more, it is unjust and it makes no sense because you have asked them to follow the legal process, which is what they're following. So you really have to, I'm just so happy right now that I'm so distracted right now because I want to get off and actually go read the court ruling because I'm just like a lawyer geek like that. But again, back to the pauses, I feel that even on the appeals, they're going to have the same agreement because again, you decided to just do this for 90 days because you claim you want to have an additional vetting, whatever. So why has it not stopped? Why have you not given the instructions that you promised to give? Because it's beginning to look like you're just trying to discriminate a certain group of people. And this is not really happening because you really should be able to do security scrutiny on a case-by-case basis like it's always been done. Every applicant goes through and undergoes through biometrics, goes through their own security. You can't just eliminate an entire group of people and just say, okay, because you're from this country, we're going to pause your stuff indefinitely. So I feel good about that. I'm just so happy to hear the 6-3. I already know the 3 who probably, voted against this, but we don't care. We're just happy to have the majority in this. So I'm very, very happy about this. Okay, guys, I got to jump off right now. But I hope you guys have a good day. And hopefully that gives you guys some hope, that not everything is necessarily doom and gloom. That's number one, where there's life, there's hope, and that, lawyers are fighting. We are all fighting our butts off, for immigrants, for human rights, that some days, work is very, 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 very hard. I was on a phone call with my mom today. My parents just recently relocated to Nigeria, after my brother passed away. And it's been, because she encourages me, I come in here to encourage you guys, but, I have a mom who encourages me because I say some days you just want to just like throw in the towel. But then there are other days that, it's like an energy infusion to fight back. You just have to keep fighting back. Like some clients in the past, if someone has an appeal, and it gets denied, like I look at the reason for the denial and I'm like, okay, but now like I encourage clients, fight back to the next court. Like I know it's tired and it's rough or whatever it is, but if you know that you're eligible for something, and this is just like, it is so difficult for people who have all this evidence, all this proof, of whatever it is, and someone just decides based on whatever it is that they feel. So the goal is not to give up, as long as you're alive. Fight as high as you can go, and hopefully the Supreme Court case, is a positive, outcome for you guys to see that sometimes, yes, you can be, thrown down, but don't give up, keep pushing. Okay, guys, I hope you guys have an amazing day. I'll be back on live tomorrow at 10 o'clock Eastern Standard Time. Again, schedule a consultation if you want to speak with me or any of the attorneys at my firm. Our number is 678-325-1037 or 678-233-2170. It's in my profile. You can also book directly online in my profile. And what else did I want to say? And then if you want someone to reach out to you after this live, you can always comment yes in the Instagram box on your comments, and then they will reach out to you. I hope you guys have an amazing day. All right, bye.